Hello everyone, welcome to Bajirao IAS Academy. In yesterday's class, we have discussed about the federal structure of the Indian Constitution and the federal features of the Indian Constitution and what are the issues between the center and state governments. And today also we have a very important concept that has been provided by the Indian Constitution implicitly, and that concept is known as the separation of powers. And in fact, when I say separation of powers, it actually means the functional separation of one organ of the government and its influence or its jurisdiction from the other organ. So this means that when one organ is working, it should not interfere in the functioning or work of the other organization or organ. So that is the separation of powers. For example, separation of powers essentially means that legislature should not involve in judiciary's work, and judiciary also should not involve in legislative work. So that is the separation of powers between different organs. So we have a legislature, executive, and the judiciary. So each of them have their own sphere of influence. They have their own sphere of jurisdiction. So one should not involve or interfere in the functioning of the other organ, and that is the essence of separation of powers. However, when we compare the Indian concept of separation powers with the US concept of separation of powers, so US concept of separation of powers is considered as a more strict and rigid. So US concept has a strict separation of powers, but on the other hand, in India, we don't have a strict separation of powers. Rather, we have checks and balances. Now, what is this checks and balances, right? So we will understand this checks and balances also. For example, Parliament's power to amend the constitution, the unlimited power of the parliament to amend the constitution under article 368 of the Indian Constitution has been limited by what? It has been limited by the judiciary through the basic structure doctrine that has been laid down by the Supreme Court in Keshwanand Bharati judgment. And even article 13 of the Indian Constitution, article 32 and article 226 as well. So these provisions actually limit the unlimited power of the parliament to amend the constitution, and this is what is called as checks and balances. So therefore, Indian Constitution, along with providing the concept or the doctrine of separation of powers, it has also provided for the doctrine of the checks and balances as well. Now, who actually introduced the concept of separation of powers? So the concept of separation of powers have been introduced in the modern Europe during the Renaissance period, right? So it was introduced by Montesquieu. So Montesquieu has introduced the concept of separation of powers between different organs of the government. And in fact, separation of powers is considered as a backbone of a democratic governance system. Backbone of democratic governance system. So therefore, as I have already told you that this separation of powers, the concept of separation of powers actually advocate for a distinct legislative, executive, and the judicial branches of the government, because I have already told you that whenever we talk about the branches of the government, there are literally three branches of the government. One is executive, and the other branch is legislative branch, and the other branch is judiciary, right? So these are three branches of the government, and the doctrine of separation of powers essentially prevent the concentration of power in these branches, and it also provides for checks and balances as well. So no branch of the government should actually have more powers than the other branch, and in fact one branch of the government will also check the other branch as well. For example, I have already mentioned how judiciary checks the functioning, or the arbitrary power, or how judiciary imposes limits on the functioning of the legislature. So in a similar manner, legislature also imposes certain checks on the Supreme Court and high courts, and in a similar way judiciary also imposes certain checks on the executive, right? So this is how checks and balances actually work. For example, how executive controls or checks checks judiciary. Judges are appointed by whom? Judges are appointed by the president, right? Judges of the Supreme Court and High Court are appointed by the president. So president is part of the union executive. So therefore this is how checks and balances actually work. So now we'll understand some constitutional provisions with respect to separation of powers, right? So in separation of powers, it is an inherent doctrine in the Indian Constitution as well, because in the beginning of the class I have already told you that this is implicitly mentioned in the Indian Constitution, right? So the doctrine of separation of powers is implicitly mentioned in the Indian Constitution. So when we are discussing the directive principles of state policy, we talked about Article 50 of the directive principles of state policy, as it specifically talks about separation of judiciary from the executive, separation of judiciary from executive, right? So this is also part of the separation of powers. And similarly Article 122 and 212 also talks about the separation of judiciary and judiciary and executive, judiciary and legislature. So all these different provisions, Article 50, Article 122 and Article 212, contribute towards maintaining a delicate balance among three branches of the government. And Article 50, so Article 50 is part of the DPSP's directive principles of state policy, and it talks about a distinct separation between the judiciary and the executive. However, Article 122 and Article 212 talks about what? So they actually talks about, these prevent courts from questioning parliamentary and legislative proceedings. So the power of courts to question parliamentary and legislative proceedings have been limited by Article 122 and 212 of the Indian Constitution. So thereby what you could see here, you could see the separation of judiciary and legislature, separation of judiciary and legislature, right? So I hope you have understood these two provisions. So Article 122 with respect to parliament, and Article 212 is with respect to the state legislature, right? So I hope it is clear for you. Now we will understand some different models of separation of powers that are being seen in major countries. For example, as I have already told you about US model of separation of powers. So US model of separation of powers is more strict, right? So strict separation of powers between the three branches of the government, unlike in India, right? So US Constitution has provided for a more stringent model of separation, so that has been clearly demarcating the functions of three branches. Now one branch should not interfere in the work and functioning of the other branch, and that is what is called as a stringent model of separation of power, and US follows this stringent model of separation of powers. However, with respect to India and United Kingdom, these countries exhibit a more fluid approach, right? So they actually follow a more fluid approach, thereby allowing for both functional and personal overlap to ensure practical governance. So that is what these countries such as India and UK follow, right? So they these fluid approach when it comes to the separation of powers, so it would allow both functional and personal overlap to ensure practical governance. And in fact, in India, we don't have a strict separation of powers, right? So instead we have a checks and balances. So that essentially means that one branch of the government checks the arbitrary and unlimited powers of the other branch of the government. So that is what we have just discussed. Now we will understand the functional overlap between executive and legislature. So to some extent we could say that there's a functional overlap between executive and legislature, right? So what type of an overlap is existing? Because see, president plays a dual role, because president is both the head of the executive and he is also head of the legislature, because once a bill is passed in the both houses of the parliament and ultimately the bill goes to president for his or her assent. So therefore president here is having a dual role as a head of the executive and also the head of the legislature. So therefore, don't you think that this is a functional overlap between executive and judiciary? There's no strict separation of powers here. And apart from that, president can also promulgate ordinances, right? The power to promulgate ordinances is also given to the president as well. For example, Article 123 of the Indian Constitution provided powers to the president to promulgate ordinances. And in fact, ordinance is also a legislation. Ordinance is also a legislation. So therefore, president's authority to promulgate ordinances, so despite being a legislative function, right? So it is a function of the parliament. Despite it is being a function of the parliament, president being part of the executive, promulgate ordinances. So therefore, this is also indicating a functional overlap between the branches of executive and the legislature. However, so the promulgation of ordinances is also a debatable issue, because Supreme Court in number of cases held that promulgation of ordinances should be done only during exceptional cases or during emergencies, right? But in recent times, very often executive has been promulgating ordinance so that it could bypass the legislative scrutiny, it could bypass the legislative debate. So the issue of ordinance promulgation, so emergency provisions. Now in fact, ordinance promulgation when both houses of the parliament are not in session. So in constitution it is clearly mentioned that when both houses of the parliament are not in session, and if time arises that promulgation of an ordinance is necessary on the part of the president, on the advice of the Council of Ministers, the president can actually promulgate an ordinance. And in fact, as I have already told you, that ordinance can be promulgated only during the times of immediate exigencies or emergencies. So in fact, ordinance promulgation is originally conceived as an emergency provision. However, so ordinance or promulgation of ordinance over a period of time after independence has increasingly blurred the lines between the executive and the legislature. And in fact, whenever the executive wants any legislation, it has been going through the ordinance route, and that leads to the violation of the separation of powers, and that also leads to the executive bypassing the legislative scrutiny, legislative debate as well. However, Supreme Court in number of cases held that it has reinforced the necessity of using ordinance power responsibly. Supreme Court in fact asked the executive that the ordinance route can be used only during the exigencies or emergencies. So therefore, the ordinance making power should be used more and more responsibly, but it should not be a replacement of the legislative functions. However, so there are certain reasons that have been given by the government for justifying its power to promulgate the ordinances. Now, what are the rationale behind promulgation of the ordinances? Now, one is emergency situations. Of course, in emergency situations, when both houses of the parliament are not in session, it is very important to promulgate the ordinances. Now, here the power to promulgate ordinances is necessary whenever there is an immediate legislative action is required to address the urgent matters. However, at that point of time, either parliament or the state legislative assembly is not in session. So, in that case, it likely happens that under Article 123 of the Indian Constitution, President can actually promulgate an ordinance. So ordinance is a legislation, so that has been framed by, or that has been made by the President, right? So President makes an ordinance under Article 123 of the Indian Constitution. And in fact, so the other rationale for justifying the power of the president or the governor to promulgate ordinance is to maintain public order and interest. Now here you could mention examples also, any ordinance that has been passed during the emergencies, so you could try to mention such examples. And secondly, maintaining public order and interest also, right? So there are instances where the ordinances have been framed or promulgated to maintain the public order and also ensure public safety, so that the rights and the interests of the citizens can be adequately protected in the absence of any proper legislative action. So for this particular reason also, ordinance can be promulgated. And in fact, so whenever any law is passed in the parliament, so that law has to go through a lengthy process of debates, discussions, legislative scrutinies, parliamentary committees, and approval of the both houses of the parliament. It actually takes a lot of time. So in order to avoid such delays in framing urgent laws, the ordinance route can be used to bypass the lengthy legislative process and also ensure that the necessary laws are enacted much promptly. So this is also the other rationale that has been given by the executive to frame the ordinances under Article 123 and Article 213 of the Indian Constitution. So I hope you have understood these three rationale behind promulgation of the ordinances by the executive. Now in this case, we will understand some Supreme Court judgments with respect to the ordinances. Now what Supreme Court has held with respect to the promulgation of ordinances. So a case, A.K. Roy versus Union of India case in the year 1982, the Supreme Court has actually upheld the constitutionality power to promulgate ordinances, right? So promulgation of ordinances by the executive, either president or the governor, it is a constitutionally valid function. And in fact, Supreme Court in this particular case has also observed that president's satisfaction is subjected to judicial review, right? So in fact, the power of judicial review to the Indian judiciary has been given by Article 13 of the Indian Constitution, 32 and 226, right? So in fact, the president cannot, or the executive cannot use the power of ordinance promulgation in an arbitrary manner. So therefore, the power of the president to promulgate ordinances is subjected to judicial review, and this is what the Supreme Court has held in A.K. Roy versus Union of India case. And the next important case is D.C. Wadhwa versus State of Bihar case in the year 1987. So remember, whenever you are writing any answer, any mains answer on ordinances, it is very important that you need to mention all these important judgments of the Supreme Court on the ordinances. And in DC Wadhwa versus State of Bihar 1987 case, the Supreme Court has actually criticized excess use of ordinances. And in fact, there is a trend both at the state level and even at the union level that the executive has been framing laws increasingly through the ordinance route. So therefore, the Supreme Court comes in and Supreme Court started criticizing the excessive use of ordinances. So ordinance route cannot be used excessively because the Constitution has held that excessive use of ordinances is against the constitutional scheme of things, and in fact ordinance shall be promulgated only during the exceptional circumstances or only during the emergencies. So this is what the Supreme Court has clearly held in DC Wadhwa versus State of Bihar case of 1987. And apart from that, so the other case that also deals with the promulgation of ordinance is Krishna Kumar Singh versus State of Bihar case of 2017. Now, what the Supreme Court has held in this recent case of promulgation of ordinances? So Supreme Court has held that re-promulgation of ordinances is a fraud on the Constitution. So this term is very, very important. Because understand one thing, the validity of an ordinance is just 6 months. The validity of an ordinance is 6 months and 6 weeks. So this is the validity of any ordinance that has been framed. And in fact, so the validity of the ordinance is that 6 weeks after the reassembly of the parliament. So if parliament don't approve the ordinance, if parliament don't pass a legislation on the matter on this particular ordinance after 6 weeks of its reassembly, then the ordinance ceases to exist. Right? So however, once the validity of an ordinance ends, then the executive again re-promulgating the ordinance so that it could permanently bypass the legislative scrutiny of that particular law. Generally, laws or legislation should be framed by the legislature. However, through ordinance route also, executive can frame legislations when both houses of the parliament are not in power. But here what executive has been doing, executive has been continuously re-promulgating the same ordinances so that it could bypass the legislative route. Now stepping into this matter, the Supreme Court in Krishna Kumar Singh versus State of Bihar case in 2017 held that re-promulgation of ordinances is actually a fraud on the Constitution. It is considered as a fraud on the Constitution. And in fact, the reasons for re-promulgating must be placed before the legislature. Right? So this is what the Supreme Court has held in Krishna Kumar Singh versus State of Bihar case. And the Supreme Court has also talked about the principle of the constitutional objectivity. So we'll try to understand what exactly is the principle of constitutional objectivity. And in fact, so a former Chief Justice of India, Chandrachud, held in National Capital Territory of Delhi versus Union of India case. So he particularly emphasized on the constitutional objectivity as a core principle to balance legislature and executive interactions. Right? So this should be a core principle to balance legislative and executive interactions, and in fact the denial of absolute power. So he also talked about the constitutional objectivity actually helps to ensure that each branch actually operates within its own designated sphere. It don't step out of its own designated sphere, thereby preventing the absolute power accumulation by any branch of the government. So that is what is called as constitutional objectivity. Now we will understand the functional overlap between the legislature and the judiciary. So there is some sort of a functional overlap between judiciary and legislature, this also existing, right? Now first we'll understand the Parliament's power to amend the Constitution. We all knew that under Article 368 of the Indian Constitution, Parliament can actually amend the Constitution. And in fact, so this principle was explicitly stated in the Constitution, and in fact it was propounded by the Supreme Court in Keshwanand. Now when we talk about this, the power of the Parliament to amend the Constitution has been limited by the basic structure doctrine that has been propounded by the Supreme Court in Keshwanand Bharati judgment of 1973. Now in this judgment of the Keshwanand Bharati judgment of the Supreme Court, it held that Parliament can actually amend any part of the Constitution, right? Parliament can actually amend any part of the Constitution, but the amendment should not alter or destroy the basic or core feature of the Indian Constitution. So this is what the Supreme Court has held that in Keshwanand Bharati versus State of Kerala case. Now in this context, we'll understand a role of Supreme Court in ensuring separation of powers, right? So the Supreme Court has actually have a crucial role maintaining the sanctity of the Constitution, and it is also known as the custodian of the Indian Constitution, right? Custodian of the Indian Constitution, right? So in fact, apart from being a custodian of the Indian Constitution, it also maintains the sanctity of the Indian Constitution, and it also ensures the power of Parliament to amend the Constitution is not used arbitrarily and to alter the basic structure of the Constitution. So in fact, Parliament cannot alter or destroy the basic structure of the Indian Constitution that is already held by the Supreme Court in Keshwanand Bharati judgment. And in fact, the basic structure doctrine that was established in the Keshwanand Bharati judgment is actually a judicial principle or a judicial innovation, that the Indian Constitution has a certain basic features, and those certain basic features cannot be altered or destroyed by the amendments that are being made by the Parliament, right? So we'll understand what is the basic structure doctrine. Now we have already discussed about this. So we have already discussed about the basic structure doctrine, and in fact in the basic structure doctrine there are certain principles. For example, rule of law is part of the basic structure doctrine, and free and fair elections is also part of the basic structure doctrine. And apart from that, democracy is a basic structure doctrine, and secularism is a basic structure, part of basic structure, and parliamentary form of government is also part of the basic structure doctrine. Federalism is a part of the basic structure doctrine, right? So in fact, Parliament can actually amend any part of the Constitution, but the amendment should not alter or destroy the features of the basic structure doctrine. So that is the essence of Keshwanand Bharati judgment's basic structure doctrine. Now we'll understand some instances of Supreme Court's intervention in this context. For example, in Minerva Mills case of 1980. So what the Supreme Court has held in this particular judgment. Now in fact, in Minerva Mills case, the Supreme Court has actually struck down clause 4 and 5 of the Article 368 of the Indian Constitution, right? So in fact, clause 4 and clause 5 of Article 368 inserted by the 42nd Constitutional Amendment Act in the year 1976, stating that a limited amending power itself is a basic feature of the Constitution, right? So in fact, the Supreme Court in Minerva Mills judgment has held that Parliament has a limited amendment power. So it has a limited amendment power, and this limited amendment power is itself a part of the basic feature of the Indian Constitution. And in fact, Parliament has no power to amend the Constitution in whatever way that it wanted. And The second instance of Supreme Court's intervention to limit the power of Parliament to amend the Constitution is Indira Nehru Gandhi versus Raj Narayan case in the year 1975. So in this particular case, the Supreme Court has declared clause 4 of Article 329A. So Article 329 clause 4 has been added by the 39th Constitutional Amendment Act, and the Supreme Court in this particular case declared this particular clause 4 as unconstitutional and void on the ground that it was beyond the Parliament's amending power, because as it destroyed the basic feature of the Indian Constitution. The other example that I can give you about the Supreme Court's interference to prevent the excess or arbitrary power of the Parliament to amend the Constitution is National Judicial Appointments Commission versus Union of India case. So in this particular case, the Supreme Court has declared the National Judicial Appointments Commission is unconstitutional, right? So the Supreme Court has declared it as unconstitutional. So it is the 99th Constitutional Amendment Act. So this Constitutional Amendment Act is unconstitutional because it violates the basic feature of the Indian Constitution. So the basic feature here is the independence of the judiciary. So 99th Constitutional Amendment Act actually violates the independence of the judiciary, and that's why the Supreme Court has struck down the 99th Constitutional Amendment Act, that is National Judicial Appointments Commission. And now we'll understand the functional overlap between the judiciary and executive, right? So there is a functional overlap between the judiciary and executive as well. For example, so the president at the union level and governors at the state level, they act as executive members, and they also wield power to grant mercy. And in fact, grant of mercy is considered as a judicial function, right? So it is being considered as a judicial function, and it also underlines the functional overlap, right? So the functional overlap between the judiciary and the executive, because here the grant of mercy is a judicial function that has been performed by the president. So therefore we can say that there is a functional overlap between the executive and the judiciary. And similarly, you can also see the functional overlap between the executive and judiciary is the tribunal system, right? So tribunal system. So tribunals are a quasi-judicial bodies, and in these tribunals both judicial and executive members, they deliver judgments, right? So in the benches of these quasi-judicial bodies or tribunals, both judicial and executive members further illustrates the overlap, right? So they work together, and that further illustrates the overlap between the judiciary and the executive. And now we'll understand the judicial overreach and its implications. And in recent times, it is being judiciary is being criticized for its activism and its overreach. So it is known as judicial activism or judicial overreach. Judicial activism or judicial overreach, right? So we have a separation of powers, but despite having separation of powers, judiciary has been criticized for interfering in the a designated area of Parliament or the executive, right? So this is what is known as judicial activism or judicial overreach, right? So in fact, judiciary legislature overlap. So there are occasions where judiciary steps into the legislative domain, right? So in fact, for example, Vishaka guidelines, one example, Vishaka guidelines that have been given by the Supreme Court. So in these Vishaka guidelines, particularly for protection of women from sexual assault offenses at the workplaces, right? So in fact, it is a legislative function, but the judiciary has interfered, the judiciary has been involved. So there are occasions where judiciary steps into the legislative domain, giving rise to judicial overreach, and that has sparks debates about the potential role and the encroachment of the judiciary over the executive into the legislature. And in fact, judiciary has also been making laws on certain matters. Now, how judiciary has been making laws? For example, there are certain landmark cases where in those landmark cases it has been seen that judiciary has been stepping in to create guidelines in the absence of relevant laws that has been further blurring the lines between the legislative and the judicial lines. So that indicates the judicial activism and judicial overreach. So that essentially means that judiciary has its own sphere of jurisdiction, it has its own sphere of influence. It should not enter into the domain of the other branch of the government, but here the judiciary has been actively entering into the other domains of the other branches as well. For example, one recent development is that in Central Vista project in Delhi, the Supreme Court has refused to consider the Central Vista project for a heightened judicial review. So therefore, here you could see a restraint on the part of the Supreme Court, a restraint on the part of the judiciary to interfere in the executive matters. Right? So such a restraint is also very important on the part of the judiciary, so that it respects the concept of separation of powers that have been implicitly provided into the Indian Constitution. Now, why the harmonious coordination between the legislature, executive and judiciary is very important, right? So it is always expected that there should be a harmonious coordination between legislature, executive and judiciary. In 80th All India Presiding Officers Conference, so in this particular conference that was held in Gujarat, it was emphasized the importance of harmonious coordination between legislature, executive and the judiciary, which are considered as three branches of the government. And in this context, we'll understand what is judicial activism, right? So what is the exactly is judicial activism? And judicial activism has been criticized for overstepping the judiciary, overstepping its sphere of influence, its domain of jurisdiction. Now, judicial activism is the proactive role played by the Supreme Court or the judiciary to fulfill or fill the executive and the legislative vacuum. For example, there is no legislation to protect women from sexual offences at the workplaces, and Supreme Court promptly framed the Vishaka guidelines to fill the legislative vacuum. So that is what is called as a judicial activism. Now, how judicial activism played a very important role in achieving the ideals of democracy, we'll try to understand this aspect as well. Right? So firstly, it plays a very important role in protection of the fundamental rights of the people. For instance, Article 21 of the Indian Constitution talks about right to life and personal liberty. And in fact, the Supreme Court over a period of time, through a progressive interpretation of Article 21, has included a number of provisions into it. For example, recently, right to healthy environment is also included as part of the Article 21 of the Indian Constitution. Right to privacy has been included as part of the Indian Constitution, particularly Article 21. So therefore, the Supreme Court has been expanding the scope and the ambit of Article 21 through its progressive interpretations of the Indian Constitution. And in fact, in Menaka Gandhi versus Union of India case 1978, the court has actually ruled the right to life includes the right to live with dignity. Therefore, the right to live with dignity is also part of the Indian Constitution under Article 21. And in fact, Justice K.S. Puttaswamy retired, and ANR versus Union of India and others case 2019, and in this particular case the Supreme Court, this judgment is also considered as a landmark judgment because Supreme Court has included privacy as a fundamental right under Article 21 of the Indian Constitution, right? So right to privacy is a fundamental right under Article 21. So therefore it also indicates the judicial activism. And secondly, public interest litigation bill. So in fact, public interest litigation is also considered as one of the potent and a very important tool for judicial activism in India, right? So in fact, the Supreme Court's in its SP Gupta versus Union of India case 1981. So in this particular case, the Supreme Court has relaxed the traditional rule of locus standi, and in fact it has also allowed any citizen of India to approach the court seeking a legal remedy in cases of larger public interest. And in fact, there are a number of instances where the Supreme Court has interfered, and the Supreme Court has also asked the legislature and executive to frame rules, to frame guidelines. For example, with respect to drought relief, the Supreme Court has, a public interest litigation has been filed with respect to drought relief, and Supreme Court has been asking center and the executive and the legislature to provide drought relief. So therefore public interest litigation is also a very, very important aspect here. And environmental jurisprudence, this is another area, right? So because as part of the progressive interpretation of the Indian Constitution, expanding the scope and ambit of the Article 21 of the Indian Constitution, so environment is also progressively interpreted. So environment has also become part of the right to life under Article 21 of the Indian Constitution, right? So in recent times, we very often see that judiciary has been playing a very active role in protecting the environment, and very often linking the protection and conservation of environment with a right to life under Article 21 of the Indian Constitution. Particularly, Supreme Court in MC Mehta versus Union of India judgment, a very important judgment in the year 1986. So it has led to the closure of several industries which have been causing pollution in Delhi, and also demonstrating the judiciary's proactive role in this particular case. So there is another case which is that is the Godwarman case, and that case is also related to the protection and conservation of the environment. And even how Supreme Court has been safeguarding secularism and social justice through the judicial activism, which is very often criticized as violation of the concept of separation of powers. But Supreme Court has also been protecting, safeguarding secularism and social justice. And in fact, Supreme Court in SR Bommai versus Union of India judgment in the year 1994. So in this particular judgment, the Supreme Court has held that secularism is part of the basic structure, right? So in fact, secularism is part of the basic structure of the Indian Constitution. So that essentially means that Parliament has a limited powers with respect to the amendment or altering the basic altering the secular nature of the Indian state. And very importantly, in Vishaka guidelines also, Vishaka guidelines were also issued by the Supreme Court for the protection of women from sexual harassment at workplaces. And later, in fact, the POSH Act has been framed by the Parliament in the year 2013, right? So protection of women from sexual harassment at workplaces Act has been passed by the Parliament in the year 2013, but the Vishaka versus State of Rajasthan Vishaka guidelines were issued by the Supreme Court way back in the year 1997. Right? So courts also directed governments to ensure social justice, such as in Vishaka versus State of Rajasthan 1997. So that has led to the formulation of guidelines for sexual harassment of women at the workplaces. Now in this context, so we need to understand checks and balances. right? So through judicial review under Article 13, Article 32 and Article 226 of the Indian Constitution, so judiciary has always tried to maintain a check on legislative and executive branches so that they will not function in an arbitrary manner. It will not lead to the concentration of powers within the executive and the judicial branches of the government, so thereby effectively preventing any misuse of power and also ensuring the rule of law, which are the key democratic principles. Right? So this is what is checks and balances, and how Supreme Court has been playing a very important role in ensuring checks and balances. Now we'll try to understand the doctrine of checks and balances. So what exactly is this doctrine of checks and balances? Now first understand the objective of checks and balances. And in fact, the objective of checks and balances is to prevent concentration of powers, right? It prevent concentration of powers within one single branch of the government, and it also prevents the misuse of power by one single branch of the government. For example, see, so if judiciary believes that executive has been misusing the power that has been constitutionally given to it, then the judiciary would step in and prevent either concentration or misuse of powers. So it is vice versa also. So thereby guarding citizens against arbitrary and tyrannical state powers, and that is what is known as checks and balances. Right? So checks and balances essentially prevent the arbitrary, excessive misuse of power and concentration of power within one single organization or branch of the government. Right? For example, if it is believed that the judiciary has been, misusing its power, if it believes that, if legislature believes that judiciary has been misusing power and power is arbitrarily concentrated with the judiciary, legislature can actually frame laws to prevent the concentration of the powers with the judiciary. Right? So that is what is known as a checks and balances. Right? So here legislature check the concentration and misuse of powers with the judiciary, and vice versa, right? Because legislature also has a certain powers with respect to the functioning of the judiciary. Now what are the provisions in the Indian Constitution which provides for the checks and balances? Right? So these include the power of judiciary to exercise judicial review under Article 13 of the Indian Constitution. So judiciary exercises the power of judicial review under Article 13 of the Indian Constitution. And in fact, binding of the judiciary by the procedure established by law. So judiciary is bound, or it is binded by the procedure established by law under Article 21 of the Indian Constitution. Now what exactly is procedure established by law? So procedure established by law essentially means that whatever parliament whatever law parliament will frame, so that law is considered as a constitutionally valid law. Right? So that is what is known as a procedure established by law. But in Menaka Gandhi versus Union of India case 1978, the Supreme Court has came up with the due process of law as well. So this due process of law is an American concept. So due process of law essentially means, or it essentially deals with the fairness of the law framed by the parliament. So along with procedure established by law, it also looks into the due process of law, deciding the constitutional validity of the laws. And apart from that, the appointment and removal of judges by the executive. Right? So executive has the power to appoint and remove the judges, and also the parliamentary form of government. Right? So these are some provisions that talks about the checks and balances, and we'll look into some examples as well. So those examples specifically deals with checks and balances in the Indian Constitution. For example, the President of India has the power to summon, prorogue and dissolve the Parliament under Article 85 Clause B and Subclause Clause 2 and Subclause B of the Indian Constitution, right? So this is also a check on the legislature by the executive. Here, what a president can do, a President of India as a head of the executive has a power to summon, prorogue and dissolve Parliament. And in fact, Parliament can also impeach President for violation of the Constitution under Article 61 of the Indian Constitution. So therefore, don't you see a checks and balances? Here, executive check and balances the functioning of the legislature, and here Parliament can also check and balance the functioning of the President as well, because the Parliament has actually been given the power to impeach the President for violation of the Constitution under Article 61 of the Indian Constitution. And similarly, checks and balances between executive and the judiciary. And in fact, the executive branch, with President as the head of the executive branch, appoints judges to the higher judiciary, both the Supreme Court and High Courts. Supreme Court under Article 124 of the Indian Constitution, and High Courts under Article 217 of the Indian Constitution, under 124 and under 217 of the Indian Constitution. And similarly, judiciary can also review executive actions through judicial review as established in several landmark judgments. And similarly, legislative and the judiciary. So the checks and balances between the legislature and the judiciary. And in fact, Parliament can actually remove judges of the Supreme Court through Article 124 Clause B of the Indian Constitution, and judges of the High Court through Article 217 Subclause B of the Constitution, right? So in fact, the judges of the Supreme Court and High Court can be removed or can be impeached by by the Parliament on the grounds of proven misbehavior and incapacity as well. Now in turn, the judiciary, the Supreme Court and High Court can actually invalidate the constitutional laws passed by the Parliament, because in Keshwanand Bharati judgment of in 1973, the Supreme Court has come up with the basic structure doctrine, and in fact, so Supreme Court can actually demonstrate the power of judicial review. So that was affirmed by the Supreme Court in Keshwanand Bharati judgment. And Parliament can actually amend any part of the Constitution, but it should not alter, destroy the basic structure doctrine. And there are some instances of checks and balances through various Supreme Court judgments. Now we'll understand what are those instances. So in Golaknath case of 1967, the 17th Constitutional Amendment Act, the 17th Constitutional Amendment Act 1964, so that has actually infringed on the fundamental rights. So that was challenged, and in fact the court has termed the legislature's power to amend any of the fundamental rights as ultra vires. And in fact, in Keshwanand Bharati judgment of 1973, the Supreme Court has actually questioned whether fundamental rights can be amendable by the Parliament under Article 368 or not. And in fact, the Supreme Court has held that even Parliament can also amend the fundamental rights as well, but it should not alter the basic structure doctrine. So this is what the Supreme Court has held in Keshwanand Bharati judgment. So Indira Gandhi versus Raj Narayan case of 1975. So in this particular judgment, the Supreme Court held that the 39th Constitutional Amendment Act that has been brought in the year instead it has inserted to regularize the election of Prime Minister Indira Gandhi. And in fact, it was struck down by the Supreme Court, citing the basic features of democracy, so that is rule of law and equality. Right? So these are some instances of checks and balances that have been enforced by the Supreme Court in this particular checks and balances aspect, right? So apart from that, the doctrine of separation of powers actually aims not only at preventing the concentration and abuse of power, right? So we have understood that the doctrine of separation, the doctrine of checks and balances and separation of powers essentially aimed at prevention of concentration of power, misuse of power, abuse of power, but it also aims at improving the efficiency of the governance by letting each branch specialize in unique functions. And in fact, this separation is crucial, and this separation is very important for democracy because it maintains a system of checks and balances that prevent any one particular branch from becoming too powerful or infringing upon the rights of the citizens, right? So in the conclusion, you could actually mention this as well. And what is the importance of separation of powers, right? So it is a safeguard against despotism, and a safeguard against dictatorship of tendencies of the government, or the majoritarianism in the parliament. It is also a safeguard against arbitrariness of the government, and it also checks on the functions of the other organs, and it helps maintaining the efficiency of administration and the governance. Now, so you could also go through this map, that theory of separation of powers as well. So that's all in this lecture, and thank you so much. So in next lecture we will be discussing few more important topics. Thank you.